We are talking about the Fourth Amendment and the law of search and seizure. It's an important topic, and law is not just for lawyers. It's got to be for everyone. My name's John Bandler. Let's talk it through together. On the left, we have an image of the Bill of Rights. That's the first 10 amendments of the U.S. Constitution. I introduced that to you in another video. It's the foundation of our system of government and law in the United States. The Bill of Rights gives many rights. In this video, we are talking about the Fourth Amendment. That's the highest law about government search and seizure in the United States. We'll review it together. It's very short, and it's been around for over 235 years. Now, who's that guy on the right? Well, he's been around for over 50 years. That was me a long time ago. I was a state trooper, meaning a state police officer in New York State. I learned a lot about the Fourth Amendment. I made a lot of searches and seizures, traffic stops, person stops, arrests, searches after arrests, searches of automobiles, searches with a search warrant. I did that for 8 years. Here I am a number of years later. A suit, no sidearm, no handcuffs, because here I'm a prosecutor, a lawyer that prosecutes crime, an assistant district attorney, and I'm with Robert Morgenthau, who was then the district attorney of Manhattan, New York County. And this was right before we did a press conference together. Now, as a prosecutor, it was my job to hold people accountable when they broke the law and when prosecution was warranted, justified, in the interests of justice. Part of that job is to analyze whether evidence seized by police and investigators was admissible. Defense attorneys would try to get evidence tossed out if it was seized in violation of the Fourth Amendment. Now, if it was lawfully seized, I tried to show the judge why. And I drafted search warrants. I might go with the cop, detective, investigator, or special agent to the judge who would review the search warrant and decide whether to issue it. So with that experience, I know something about the Fourth Amendment. I wrote a book on Cyberlaw, and this is the book. I tabbed it because I teach with it. And I have a chapter in it just on the Fourth Amendment. That's chapter 11, and this video parallels that chapter. This is what the start of chapter 11 looks like. And it's called the Fourth Amendment and Government and Search and Seizure. And I start that chapter with a statement, a simple statement of what I think the Fourth Amendment is about. And I'll read that to you now. The Fourth Amendment protects us from unlawful and improper searches and seizures by the government. As with the First Amendment, it is a protection from government action. And that's from page 111 that you just saw. If you've seen my other videos on law, you remember how I categorize laws and break them down. And here's a quick recap. So law is this big green box. That's all law. And law is for everyone. It's for you. It can't just be for lawyers. The blue box is Cyberlaw. I wrote a book about it. The cover looks something like this. And Cyberlaw is a subset of all law where technology and law intersect. I'm working on this new book, Introduction to Law, which will also cover the Fourth Amendment. Let's forget about Cyberlaw for now and think of an important way to categorize law. Let's think about criminal law. That is especially important with the Fourth Amendment, and let's think about civil law. Now, I introduced this in another video. Criminal law is that area of law where police could arrest you for violating it, and then the process of resolving that litigation, that criminal prosecution. And civil law is almost everything else. Think of constitutional law as running across both of them, sort of like this. And within constitutional law, part of that is Fourth Amendment law, which looks a little like this, but I'm going to fine-tune that in a moment. But let's take that away and think about what's within criminal law. Within criminal law, we have substantive law. That's the laws police can arrest people if they violate that law. And then we have procedural criminal laws, and that's laws relating to how law enforcement can investigate crime and prosecute crime. Part of investigating crimes means seizing evidence. And when we talk about gathering evidence, we need to think about the Fourth Amendment. So let's think of how we're going to draw that. If we put constitutional law like this and Fourth Amendment law here, it really doesn't do justice to how important the Fourth Amendment is to procedural criminal law. So I'm going to extend that constitutional law box and I'm going to extend that Fourth Amendment box. And I think this helps show visually how important the Fourth Amendment is to that process of investigating crime. And then when it's being adjudicated, the judge needs to consider whether the Fourth Amendment was followed or violated by law enforcement. As police and agents are investigating, the Fourth Amendment is one of the most important restrictions upon them, and it's a protection for defendants, and it's a protection for all citizens and residents from government overreach. So the Fourth Amendment is the highest law in the country on government search and seizure. Now, there may be criminal statutes, criminal procedure laws that relate to search and seizure, but they all need to comply with the Fourth Amendment. That's the highest law. It protects us from unreasonable search and seizure by the government, and it does not protect against private searches, private seizures, private takings, although other laws may provide protections. Laws in criminal law and civil law may prevent people from doing that, but not the Fourth Amendment, because the Fourth Amendment deals with a protection from government. From the Fourth Amendment, we have an enormous body of case law, meaning decisions by judges, and that case law has evolved what the Fourth Amendment means. Let's read the Fourth Amendment of the U.S. Constitution together. It's only 54 words. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, within those 54 words, there are some key words, and you can imagine lawyers and judges have parsed every single word. The right to be secure in your person, house, papers, and effects, unreasonable searches and seizure, warrants have to be supported by probable cause, supported by someone swearing to them by oath or affirmation, and describing with particularity, right? Not general, but describing it, the place and who or what is to be seized. That is the text of the Fourth Amendment. Those are just a few words from a long time ago, but they mean a lot. So that Bill of Rights, including the First Amendment, it became effective in 1791. The word count, only 54. The words have never been changed in over 200 years. The law, lawyers, judges needed more words to explain what those 54 words mean. And that happens all the time in law. A statute, the Constitution, it's a limited amount of words, and then lawyers and judges try to apply it to other circumstances. This Fourth Amendment was toothless for almost 125 years until a U.S. Supreme Court case known as Weeks was decided in 1914. And what I like to say is the case of Weeks gave the Fourth Amendment some weak teeth. All of a sudden it had some teeth, but they were still weak. And then another court decision, Mapp, came in 1961. That gave it more teeth. That applied it to the entire country, all government and law enforcement. Those 54 words, how many words do you think lawyers and judges and other commentators have written about the Fourth Amendment? Easily millions, probably billions. If you've got some interest in math and law, there's a way to figure this out. I only did a back of the paper napkin analysis. Let's hammer home an important principle. The Fourth Amendment applies only to government actions. So if a private party takes your stuff, maybe it's a crime, maybe it's larceny, theft, maybe it's a civil tort of conversion, but it does not involve the Fourth Amendment. So when we're analyzing whether the Fourth Amendment applies or not, we look to see whether there was government action. Government action is also known as state action. So in criminal cases, judges might grant a state action hearing to determine whether there was state action or not. And if the judge decides there was state action, the judge will apply this Fourth Amendment reasoning, potentially exclude or suppress evidence. We'll talk about that in a moment. If the judge decides there was not state action, then the judge will decide that the Fourth Amendment doesn't apply. The Fourth Amendment imposes a search warrant requirement on law enforcement, and that's the first general rule. And like almost every rule in law, you have exceptions to the rule. And there are a lot of exceptions to this rule. And the reason for these exceptions is it is time-consuming and cumbersome for police to obtain a search warrant. And there are circumstances where we don't want police to take the time to get a search warrant, or we realize that would be impractical or impossible. So some of these exceptions to the search warrant requirement, they include for consent, if the person gives voluntary and knowing consent to give up that evidence, that property, to allow that search. If it's in plain view of law enforcement who is already in a lawful vantage point. If it's search incident to lawful arrest, and at the DA's office we abbreviated this SILA, SILA. If the officer has made a lawful arrest, they're entitled to do a certain search of the person and maybe their grabbable area. There's pat-down frisks if law enforcement has reasonable suspicion the person might be armed. We'll talk about that. There's automobile searches. If there's probable cause, there's evidence in there. That's known as the automobile exception. In emergencies and when law enforcement are in hot pursuit, and something called the automobile inventory. If law enforcement has a policy and they regularly, when they impound vehicles, do an inventory of it, looking for valuables or dangerous items. Let's talk about the exclusionary rule. The exclusionary rule means that when law enforcement violates the Fourth Amendment, any evidence they seized improperly will be excluded from the trial, meaning suppressed. That means the jury will never see that evidence, will never hear about it. Now, this exclusionary rule comes from the 1914 United States Supreme Court case of Weeks versus the United States that I mentioned before. The exclusionary rule also applies to other areas of criminal law where law enforcement takes an action that illegally obtains evidence. The judge will exclude it. This includes stops, searches, and seizures. That's from the Fourth Amendment, what we're talking about here. It also includes confessions and statements by defendants. That's under the Fifth Amendment, and it also includes witness identifications of a defendant. That's a Sixth Amendment issue. Who gets to say what the Fourth Amendment means? Everyone's got an opinion. You do, I do. But judges' opinions matter more than ours, especially in a legal decision, because that's making case law. It's interpreting the law. It's making new law. So the U.S. Supreme Court, they have the ultimate authority to decide what the Constitution means, including the Fourth Amendment. And we have to remember, judges are humans. That means they are imperfect, just like you and me. But there's some tension and some balancing factors that go into this. One aspect is, what does the Fourth Amendment mean as written? Or sometimes that turns into, what should it mean? And we also want to balance law enforcement's need to investigate and apprehend. And we want to balance that with the rights of people against unreasonable searches and seizures, protections for defendants and all of us against government overreach. There has been an evolution of Fourth Amendment law over the hundreds of the years. It evolves for the times, including for technology. Remember, it was ratified in 1791. We had Weeks versus the United States in 1914. And I'm showing you the case citation. I just highlighted it. So U.S. right here, that tells us it's a U.S. Supreme Court decision. The 232 tells us the book. 383 tells us the page number in that book. And 1914 tells us the year. That's the case citation. It helps us identify a particular case and cite it for a proposition, cite it as law. Now, Weeks stand for the proposition that a warrantless seizure by federal law enforcement from a private residence violates the Fourth Amendment. They didn't have a warrant. The judges say that because it was seized illegally in violation of the Fourth Amendment, it must be excluded or suppressed. So that's that suppression exclusionary rule. the first time that the Fourth Amendment had teeth. Then we had Bordeaux versus McDowell, 1921. The principle of that is that searches by private parties, even illegal searches, do not implicate the Fourth Amendment, so suppression is not a remedy. Then Mapp versus Ohio, Supreme Court, 1961. This is the first time the Supreme Court says the Fourth Amendment applies to states, meaning to state and local law enforcement, not just the federal government like they said in Weeks, but to all government. Then we have Katz versus the United States in 1967. This is about a wiretap. And here the Supreme Court says the Fourth Amendment applies to conversations too, to telephone conversations, which in Katz the FBI eavesdropped in without a warrant. So now you need a warrant, or it's known as a wiretap order. Then in 1968, we have Terry versus Ohio, where Supreme Court grapples with the issue that law enforcement is allowed to arrest with probable cause, but what do they do if they have something less than probable cause? So in Terry versus Ohio, the Supreme Court says police can do a Terry stop if they have reasonable suspicion that criminal activity is occurring or about to occur. They can detain people temporarily, perhaps even do a pat-down frisk of their outer clothing. So probable cause has always been the standard for an arrest, but in Terry versus Ohio, the Supreme Court gave police one more tool if they had reasonable suspicion, but not yet probable cause. Now, I'm going to talk about this tweet or post or whatever it's called from Department of Homeland Security. We're going to talk about that in a moment, so just stick with me. In cyberspace, does the Fourth Amendment apply? How could this amendment from hundreds of years ago apply to something new like technology and the internet and cell phones and smartphones? Well, the answer is clear. The Fourth Amendment definitely, absolutely applies in cyberspace, and that shows the legal evolution continues, including with computers and the internet. We have the case of U.S. versus Jones regarding GPS tracking, where the Supreme Court said that's a search. You need a search warrant supported by probable cause. Riley versus California, search of a cell phone. The Supreme Court says you can't just do a search incident to lawful arrest without a warrant of that. You need to get a search warrant. Carpenter versus the United States. Here, third-party location data. For example, your cell phone company tracking your location. It's held by a third party. The Supreme Court says to get that, you need to show probable cause, meaning a search warrant. Let's talk about this tweet, or whatever this post is called now that Twitter is X. This is a screenshot from when the post was over 24 hours old. It's wrong. They could have corrected it. Now it's 48 hours. They still haven't corrected it. And look how it says law enforcement uses reasonable suspicion to make arrests. As you know by now, that is wrong. And they haven't corrected it, although other people on X have corrected it. They point to law.cornell.edu. Great website for getting legal information. Put a link to it in the description. Now, the internet is a powerful method to convince and influence what happens when organizations or people put out false information. Well, we need to correct it. We need to engage our brains. So I'm going to fix this first sentence. I removed or grayed out some of the other text to avoid that distraction. And this is how we fix it. Law enforcement must have probable cause to make arrests. That's the Fourth Amendment. That's the law. Now let's recap. Let's talk a little about police-civilian encounters in the Fourth Amendment just to drive the point home. First, remember, I'm giving you armchair law information. I'm not giving you legal advice, and this is not a video about how to interact with the police. But let me just say a quick word on that. And remember, encounters between civilians, citizens, residents, and police, they can be stressful for everyone. Now, police should not escalate those encounters, but neither should the citizen or civilian or resident. Police may have information you don't know about. They definitely have tools and authorities you don't have. Many Many in law enforcement are just trying to do their job, so I'm going to suggest be polite, be courteous, no sudden movements, never use force, never resist, even if you think you're being falsely detained or arrested. Okay, with that out of the way, let's talk through these two main thresholds of facts, or call it proof on the street there. Probable cause. Probable cause a person committed a crime means custodial arrest is authorized, including search incident to lawful arrest. We abbreviated that as SILA. Probable cause is not a super high standard. It really means probably, more probable than not. It's not proof beyond a reasonable doubt, so it's not a huge standard. But there is a standard lower than that that matters. That's reasonable suspicion. It's lower. It's specific facts the law enforcement can state, meaning articulable facts, that criminal activity is occurring or about to occur. And reasonable suspicion allows a temporary detention, known as a Terry stop, to investigate and see whether there's probable cause to arrest. If so, then you're in the probable cause area. If not, you need to let the person go. A little plus sign here. If the officer has reasonable suspicion to detain and reasonable suspicion the person is armed, they then could also do a limited pat-down frisk of the outer clothing for the purpose of checking for weapons. So those are the important distinctions. I clarify it, especially in light of that tweet from Department of Homeland Security. New York State is even stricter. There's something called the DeBoer Doctrine. We'll save that for another time. Here's some important takeaways. Don't forget to like, comment, and subscribe. Fourth Amendment is the highest law in the U.S. on government searches and seizures. It's a protection against unreasonable searches and seizures by the government. It imposes the search warrant requirement, but also know there are many exceptions to that requirement. Law enforcement needs probable cause to get a search warrant and to arrest someone, and the Fourth Amendment applies in cyberspace too. For a deeper understanding, see my additional resources. Those will be in the description and the next slide. My Cyberlaw book, Chapter 11, and my next book on Introduction to Law. Again, don't forget to like, subscribe, and comment. Thanks so much for listening and getting to here. References will be in the video description. I've got other YouTube videos. I got a companion article on the Fourth Amendment on my website, articles and videos on law. So thanks again for listening. Don't forget to like and subscribe. Take care.